When a Denver public school security guard searched a student on a safety plan in 2019 and found a loaded handgun, they arrested that high schooler. His lawyer says the search was unconstitutional. Now it's made it to the state Supreme Court. Here's Cole Sullivan on what this upcoming decision might mean for school safety.
When a student shot two administrators searching him at Denver's East High School in March, it was the first time most of us had heard of a safety plan. DPS had used them for years.
It's part of what we have in terms of making sure that we can support the needs and behavioral needs of students.
In 2019, DPS security officers searching a high school student found a loaded handgun in his backpack.
Everybody agrees that keeping guns out of schools is among the most compelling of government interests imaginable.
But 4 years later, lawyers are still arguing here at the Colorado State Supreme Court whether that search under a safety plan violated the student's Fourth Amendment right. That's the one against unreasonable search and seizure.
There is absolutely nothing in the record about what anybody told him.
The kid's public defender says he did not know he was under a safety plan, and he needed to know for the search to be legal. The state agrees with the second part.
I think a juvenile who is going to be subject to a safety plan has to be on notice that there is a safety plan in place.
But she says he should have known because it was the same safety plan the previous school year.
There's no expiration.
And the state Supreme Court seemed inclined to agree.
This doesn't feel like gotcha because he'd been subject to this protocol the year before.
However the court decides, it will define how clear schools must be ahead of time for their searches to be constitutional, impacting rules of safety plans for students deemed so dangerous, schools must search them daily before class.
The court is not expected to rule for several months. One of the reasons why the notice for these safety plan searches must be clear is because they're supposed to act as a deterrent almost more than anything else. The logic being if a student knows they're going to be searched, they're less likely, Kyle, to say bring a gun to school with them.
So if the court does something that impacts these student safety plans, is that going to tie the hands of the people doing this work in schools?
It could tie the hands of the work of the people doing this in schools, mostly just that they have to give more clear notice and make sure that the students know that they have this safety plan and that they will be searched, again, to serve as that kind of deterrent.
And they have other options if they need to search kids.
Absolutely. The two main options constitutionally these lawyers laid out. One, if they have reasonable suspicion the student is doing something illegal or wrong or dangerous. The other, if they search a large group of students, that also is aimed to serve as a deterrent more than anything else.
Cole Sullivan, thank you.